So it's left to men like Davis Younts to fight for these Navy
As
SEALs.
you know, I represent Navy SEALs, fighter pilots, Coast Guard rescue swimmers.
Pennsylvania attorney R. Davis Younts successfully defended an evangelical Navy lieutenant.
Lawyer R. Davis Younts says by doing this, the military may have violated the constitutional rights of U.S. troops.
You are an attorney who has successfully defended naval officer Lieutenant.
Hey everyone, Attorney Davis Younts here. As you can tell, we're working from home and I've stepped outside to get a few minutes of fresh air. Listen, with everything that's going on with this national crisis, all the emergency and disaster declarations that are out there, I've been thinking a lot about the Second Amendment rights of all American citizens, but in particular, veterans. And here's why. Listen, there are things in a military record that can prevent a veteran from purchasing a firearm or getting a concealed carry permit, and it just shouldn't be the case, or they may be related to some sort of an error or something else. So here's what I've learned in my practice and as a veteran myself. There are certain things that show up in military records that do have an impact on your Second Amendment rights. And it really falls into three things. First is military convictions. Military member that was ever court-martialed and was convicted, really whether it was a summary, a special, or a general court-martial, there is a significant possibility that that conviction will prevent them from purchasing a firearm or will prevent them from getting a concealed carry permit. And it's not really fair, and it's not really the way the law is designed or intended, because the military doesn't necessarily categorize offenses or convictions as felonies or misdemeanors. And when states look at those military convictions, they have to do a comparative analysis. They have to try to do some sort of an apples to oranges comparison to try to figure out what a conviction for AWOL or violating a lawful order really means in the civilian world. And that creates a significant problem for a lot of veterans who do have a court-martial conviction. So that's the first area. The second area deals with military investigations. And I've talked about this a lot. It's something I'm very passionate about because I don't think it's really fair to veterans. But the bottom line is, if you were read your rights by military law enforcement at some point in your career, there is a significant chance that you were titled, and what that means is that your information was put into the National Criminal Information Center database and that it will show up in an FBI background check. I mean, think about that. Even if you were never charged with a crime, never taken to court-martial, maybe you were just given counseling, maybe you were just given a GOMAR or an LOR, maybe you just went to MASS and got NJP, but it looks to civilians like you have an arrest record and some sort of criminal history, and that can prevent you from purchasing a firearm or getting a concealed carry permit. The final thing that I've seen in my experience is that some states and some jurisdictions have created weird rules about what they expect to see on a DD-214 when it comes to, if not the purchase of a firearm, getting a concealed carry permit. Now, how it works is this: some jurisdictions have said if you don't have an honorable discharge, if you have a general or an other than honorable conditions discharge, you can't get a concealed carry permit in that jurisdiction or in that state. Now, to me, I look at that as really unfair and really an unfortunate and impermissible restriction on your constitutional right to bear arms. An administrative separation is just that. It's not a criminal conviction. It's not a criminal process. So it's really important that veterans do everything they can to make sure that some sort of administrative process like that, some sort of administrative record, something on their DD-214 doesn't prevent them from purchasing a firearm or getting that concealed carry permit. Now, that's the bad news. Here's the good news. For each of these issues that may be preventing you from purchasing a firearm or getting a concealed carry permit, there is a solution. There's no silver bullets, there's no guarantees, but it is possible to appeal a court-martial conviction. It is possible to have the type of discharge that you received, whether it was especially if it was a bad conduct discharge, really, downgraded to an administrative discharge, and that may help. If you were titled by military law enforcement and some sort of a record is showing up in your criminal background check, you can petition the headquarters of your services law enforcement agency. So whether that's CID, NCIS, Coast Guard Investigative Services, or OSI, you can petition to have that titling action either expunged or amended. Now, finally, military members have the right to have their records corrected and their discharges upgraded. Each of the branches of service has a review board's agency that has the ability to upgrade discharges and to correct military records. It's not an easy process, it's not a fast process, but there is that possibility. There are resources out there available, and I hope that veterans educate themselves on this process and understand that errors or other things in their military records can have an impact on their Second Amendment rights. And unfortunately, whenever we see any sort of a national emergency going on or any sort of a crisis declared, there are politicians that will look to enact legal provisions that will infringe upon the Second Amendment. And it seems to me, in my experience, that veterans are often the first victims of that, because any restriction of the Second Amendment can be impacted by what's in your military record. So if anybody has any thoughts or ideas on this, feel free to share them, or feel free to reach out to us or to me, and I'm happy to chat and provide you any information I can. Stay safe out there and be well.